are innovating to provide effective dispute resolution while not compromising on quality in the context of increasingly complex shipbuilding disputes. Before we get started, I will run through a couple of housekeeping notices. Could I please ask all participants to mute their microphones and turn their cameras off? The panel will be answering questions. However, could I please ask you to put your questions in the chat function? And I think we'll also be very happy to receive questions either in Korean or English. I'm sure that the panel will also be happy to receive queries after the session has ended, and I think all of the panel's details have already been sent to participants. And lastly, this webinar is being recorded and will be sent to all attendees. May I also take this opportunity to thank the Department for International Trade teams, both in Seoul and London, today's presenters, especially Hill Dickinson, whose idea this event was, and lastly, my special thanks to the Korean Shipbuilders Association for supporting this meeting today. I very much hope that this event will mark the start of a more proactive engagement between our respective markets. It now gives me the honour to introduce Her Majesty's Ambassador to the Republic of Korea, His Excellency Colin Crooks, who will deliver the opening address. Ambassador, thank you.
Thank you very much. I will, for that introduction, I'll deliver a few remarks in Korean, if I may. 안녕하십니까. 저는 Colin Crooks, 신임 주한 영국 대사입니다. 한국의 조선업계와 영국의 해양 서비스 업계 대표 및 전문가들이 한 자리에 모인 이니시티브에 참여하신 것을 환영합니다. 1970년대 영국의 해양 엔지니어와 디자이너들은 한국의 주요 조선 기업들에게 지식과 전문성을 공유해 한국의 조선 해양 부문의 기반을 마련하는 데 기여했습니다. 2020년대인 현재 저는 이러한 협력이 더욱 확대될 수 있기를 기대합니다. 전 세계적으로 코로나19 대유행과 더불어 선박에 대한 수요가 증가하고 있습니다. 또한 조선 해양 분야에서 지속 가능한 탈탄소화에 대한 요구도 높아지고 있습니다. 이는 조선업체, 선박 소유주 및 선박 운영업체 모두에게 도전이 될 것입니다. 영국 정부는 이번 달 조선 해양 산업에서 지속 가능한 미래를 확보하기 위해 새로운 국가 조선 산업 전략을 발표했습니다. 영국은 향후 3년간 조선 부문에 40억 파운드를 투자하고 녹색 기술 상용화를 위한 해양 부문 연구 개발에 추가로 2억 600만 파운드를 투자하는 것을 목표하고 있습니다. 조선 해양 강국인 한국은 영국이 지속 가능한 선박을 만들고 해양 기술을 개발하는 데 있어 중요한 파트너입니다. 영국은 기술과 전문성을 통해 세계 최고의 조선 강국이 되려는 한국의 포부를 지원할 수 있습니다. 이에 한국 조선업계에서 경험이 많은 해양 사업 개발 매니저가 곧 저희 영국 대사관 국제통상부 조선해양팀에 합류하게 될 것을 알려드립니다. 이번 웨비나에서는 건조 단계 및 조선 계약 이후 제공되는 영국의 법률 서비스와 분쟁 해결 관련 전문성이 조선 해양 기업들과 고객 모두에게 어떤 혜택을 제공해 드릴 수 있는지에 대해 논의합니다. 마지막으로 이 행사가 영국의 해양 분야와 한국의 조선 분야 간의 관계가 더욱 돈독해지는 첫걸음이 되기를 바랍니다. 감사합니다. Thank you, and I will hand back to Joss.
Ambassador, thank you so much for those remarks and taking the time out of what I'm sure is an exceptionally busy schedule to address us all this morning, or this afternoon, as it will be in Seoul. I will now like to pass over to Ben Goss, who has been recently elected a full member of the LMAA, who will be moderating today's session. Ben, thanks very much, and I'll now pass over to you.
Thank you, Joss, and thanks also to Ambassador Crooks for those opening remarks, and to the Department of International Trade and Maritime London for hosting today's event. Good afternoon, everybody, and thank you for joining us. May I start by saying what a privilege it is to moderate today's event. The format for this session is that each speaker will give a short presentation of about 10 minutes each, following which we've scheduled some time at the end for questions. As Joss said, please ask any questions which you would like the panel to address using the chat function on your screens. You can do this at any time during the presentations. We will collect them all and try to address them at the end. Please also feel free, as Joss indicated, to ask your questions in either English or Korean, whichever you are most comfortable with. We have Jeff Park from Hill Dickinson with us today, and he's kindly agreed to provide translation. So if you prefer to write your questions in Korean, you are very welcome to do so. The topic of today's discussion is contractual delays and what can be done to speed up resolution of disputes under English law. If your contract incorporates an arbitration agreement, which shipbuilding contracts commonly do, then that arbitration is governed by the Arbitration Act 1996, Section 1 of which states that the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. The Arbitration Act of 96 has helped London to achieve preeminence as a seat for arbitration and is, for the first time in 25 years, under review by the Law Commission to see if it is still fit for purpose and how it can be improved. Disputes have certainly become more complex in the intervening period, which is inevitable where projects have become more technical and the sums involved have escalated. Delay claims have been a particular problem for shipyards, some of which have failed because the yard was not able to sufficiently prove its claim. So what can be done to improve matters? To address this, we have an illustrious panel consisting of a shipbroker, 2 lawyers, a barrister and an arbitrator, and it is my privilege to introduce each of them as we go along. Now, as disputes generally start out as technical or commercial issues, which, if unresolved, escalate into full-blown legal disputes, we thought it appropriate to start today's discussion by looking at disputes from a commercial broker's perspective, before then moving on to the legal aspects. So our first speaker is Thomas Bracewell. Thomas is a naval architect and shipbroker, and part of the Newbuilding team at Arrow Shipbrokers, where, amongst other things, he leads Arrow's work on maritime decarbonisation. So Thomas, over to you.
Thank you very much, Ben, and thank you for the opportunity to speak here today to you and to the DIT. And yeah, so as Ben says, I'm a Newbuilding broker. I work for one of the largest independently owned broking shops, Arrow. We have 16 offices around the world, including offices in the big 3 Asian shipbuilding centres of Japan, Korea, and China. We're about 30 S&P brokers who are all engaged in Newbuilding, but of that team, there are 8 of us essentially who are focused very directly on the Newbuilding business and speaking to the shipbuilders as well as clients. And so you'll be pleased to know, actually, my experience of claims relating to delay has all been with shipbuilders in China and never in Korea. But I do hope that some of these thoughts that I'm going to share are useful today. I want to first of all highlight the value of a professional Newbuilding broker in disputes at an early stage between the buyer and the builder, no matter what that dispute may be. Certainly at the outset of a problem and in the early stages. If I look across the field of serious shipbroking businesses in London, I see many very qualified Newbuilding desks They are not typically they are not fix and forget type characters on these new building desks. They are there to work through the through the construction process with the buyer and the builder, and brokers are increasingly providing consultancy and advisory services, and we're normally investing significant time in advance of constructing ships. It's not just a case of fixing the way we do a charter, and so we are significantly more involved than maybe is often perceived from the outside, from both the building and the buying side. So we're very motivated for our contracts to be successful because we've invested so much. We want our ship owning clients and our shipbuilder clients to be successful, and want both parties to feel support by us through all stages of the project. We do not have a new building post-fixture department, but instead it is down to us, mainly eight new building brokers, to see business through to its conclusion. And because we are so invested, we believe this is the right way to act. Certainly, I would almost see myself as a project manager beyond the contract signing stage, or beyond the LOI signing stage. And myself, I'm a naval architect, and we have within the team, we also have legally trained. We have people with experience on the technical buying side of equipment, and so on and so forth. So we have quite a lot of experience, and whilst we do not have limitless time and resources, with the legal and engineering capacity that might be required to mediate disputes, many of us do have a lot of experience. We certainly have probably 200 years of experience across our desk, and we likely also have the ear of the ship owner, which is incredibly important in so many cases when it comes to dispute. What I'd like to do is I'd like to highlight two experiences I've had, both of which have been in China, where delays have been caused by technical and construction issues, with very different outcomes. The first was with a very highly regarded builder, and through an assumed but unproven negligence of one of the builder's subcontractors, there was a fire in the engine room of a vessel which was almost ready to be launched. The fire caused significant damage and many months' delay. Whilst the builder issued notice of force majeure, on our advice as broker, they immediately and proactively struck up a dialogue with the buyer alongside, and we negotiated a sensible resolution within a matter of weeks. Whilst there was a cost to the builder in doing this, a financial cost, I believe it was a much smaller price to pay compared with if they had maintained their force majeure claim and followed that route, from both a financial perspective and reputational perspective. And in the end, I believe everyone was very satisfied with the outcome. The other experience I've had, and I'd like to share, was very different. I was involved in contracting a long series of bulkers at a lesser known yard in China, and the case became very well known actually, but the first two in the series passed sea trial and went into service, and in service the owner became aware of a couple of design deficiencies. The owner had a third-party report made, which perhaps made more of the technical issues than made them sound more severe than they really were, but nevertheless the issues were real and they needed fixing, but fixing them was eminently achievable for the rest of the series of vessels without significant delay, with cost to the builder, but not huge. So we tried to encourage the builder to update the vessels, even if contractually they did not feel obliged. And as broker, we were very aware of how the owner involved in this project might act, particularly as the shipping market at the time was in a weak or weakening relative to when the vessels were being contracted. But unfortunately, the shipbuilder was not willing to be held accountable, and would not absorb the cost, which we felt at the time was probably going to be about 2% of the contract value, so relatively insignificant. Initially, the builder just denied the problems and then blamed the ship design house, which may have been a fair way of apportioning blame, but wasn't necessarily a commercially sensible thing to do at the time. So what happened is the vessels were delayed. as this dispute rolled on, having a knock-on effect on subsequent ships in the series. And ultimately, the case ended in the English Commercial Court, becoming a well-known examination of the applicability of the prevention principle. And in the meantime, the shipbuilder had collapsed, largely as a result of this case, or as a result of the problems and this dispute as a whole. It's probably a good example of where, if the builder had been willing to listen to the broker in the first instance, probably a little bit more, and for someone to stand up at the shipbuilder and say, okay, I'm to blame, you know, this has gone wrong, but let's find a resolution and move on, and come to the table as we'd encouraged, then the buyer at the time would probably have had no choice but to also come to the table, and we'd have had a much better chance of finding a resolution, whether it was a discount or whether it was changing the propeller and various other things at the time. But I feel that the builder would have ended up in a much better place. So I think, you know, I give these two examples just to give a feel as to how maybe we can get involved at an early stage and where it could be successful and so on. I do not suggest we are a replacement for sound legal advice or professional dispute resolution at all. But I just urge builders to listen to the broker in the first instance, and neither that or don't either forget us as someone to come to through the legal discussion, because we might have points to add, and often I find that once something has gone to a legal discussion, we're completely cut out of the discussion. You know, there may be conflicts of interest which lead to that, but sometimes I feel like we still have quite a lot to add and don't have the opportunity. And I think, you know, I think actually this conversation is a very topical issue at the moment as broker, as we're discussing today, seeing the largest ever container order book and various technical bottlenecks in the construction capacity for these vessels. There no doubt will be delays over the next few years, and I fear some owners may be tempted to use these to their benefit in the fullness of time as the container market inevitably normalizes at some point and earnings decrease. You know, it's almost bound to happen, I think. So this is indeed a very topical issue. But thank you very much for listening to me, and I'll pass back to Ben for your notes. Kamsahamnida.
Thank you, Thomas, for a very insightful broker's perspective. You've undoubtedly provided some food for thought, especially regarding whether brokers are utilised as well as they should or could be when issues arise, and whether yards should make better use of the broker, especially at the early stages of a dispute. I think it's certainly true that generally the earlier that issues are addressed, the quicker and easier they are to resolve. And there's no doubt that the broker can potentially play a key role at the early stage of a dispute and has a vested interest in doing so. We're going to stick with the theme of dispute avoidance and commercial solutions for 5 minutes longer, whilst I talk briefly about dispute boards, before we then move on to more legal aspects. A dispute board is a panel usually consisting of 1 to 3 people appointed by the parties to the contract, so builder and buyer, to assist and oversee performance of the project, to provide an independent perspective, and when needed, impartial advice. Whether a dispute board is made up of 1, 2, 3 or more people is up to you. Sometimes parties to a contract mutually agree on one person to act as a dispute board to save on costs. Otherwise, each party appoints one person each, and those two appoint a third, much like what happens when forming an arbitration tribunal. The point is the parties control who they appoint, and by doing so, they also decide what experience and background they want their dispute board to consist of. So the dispute board is tailored precisely to the needs of the parties and to the project. The key to success with dispute boards is undoubtedly appointing the right person or people to make up the dispute board. Clearly, the dispute board members need to have specialist skills and experience that is relevant to the contract. but you have to decide what skills are most relevant and important. It could be particular technical or engineering knowledge or legal knowledge, for example, or you might require someone who can act essentially as a mediator, who both parties feel they can trust and have a good relationship with. Often it's a combination of all these things, but it's completely up to you to define what criteria should apply to choosing the right dispute board members. And that often depends on the nature and scope of the project and who you are contracting with. The role of the dispute board ultimately is to assist you to keep the project on track by following progress of the construction via reports and attending regular management meetings. So nothing that isn't happening already. A dispute board should not mean an extra layer of reporting. It's more about having an independent, impartial person follow the project, provide a third-party perspective, and help to overcome obstacles when they arise and before they become full-blown disputes. If an issue can't be settled commercially, either party can apply to the dispute board to make either a recommendation or a decision. The dispute board is in a good position to do this because they're seeing the project live as events happen and they're aware of the background. They also have access to the documentation relevant at the time, so that should all save time. You decide what powers to give to the dispute board. They can either make non-binding recommendations or binding decisions. Either way, a dispute board provides your project with a framework for reducing delays and keeping projects moving forward. Outcomes respect and maintain contract provisions and allocation of risk, and it's a merit-based process that maintains integrity and procedural fairness. That said, dispute boards are not intended to be a substitute for recourse to court or to arbitration, and most contracts which provide for a dispute board also specify that final recourse is to arbitration or to the courts. So decisions by a dispute board are interim binding. That is, they're binding unless and until they are subsequently overturned by an arbitration award or court judgment. So much like the decision of an adjudicator. I should emphasize that dispute boards are not intended to replace the need for you to maintain your own effective project management. You remain responsible for performance of your contractual obligations and project management. The dispute board is there to assist, but not to take over. You should think of a dispute board as contributing to good governance. They create an atmosphere of collaboration and transparency between the parties and bring a dispute avoidance attitude to the project. Dispute boards have been adopted all around the world on large-scale construction and infrastructure projects like bridges, roads, tunnels, power stations. The Olympic Games in Rio de Janeiro in 2016 and London in 2012 even employed dispute boards. Multilateral development banks, including the World Bank, often insist on them in projects that they fund because dispute boards are regarded as benefiting complex projects with multiple stakeholders, which is perhaps why they're something for shipyards to consider. Shipbuilding has become increasingly complex with more and more sophisticated technologies being deployed and regulatory demands ever tightening. Statistics provided by the Dispute Resolution Board Foundation, DRBF, suggest that projects that involve a dispute board have fewer disputes and less litigation. In a 2018 study, they captured just under 3,000 completed projects where a dispute board had been used and a total construction value of in excess of $280 billion. And according to their analysis, over 85% of disputes which were referred to a dispute board for a decision did not go on to be challenged by subsequent court or arbitration litigation. The dispute board decision was accepted and put an end to the matter. So that amounts to significant savings in time, resources, and ultimately money. I hope that's provided some food for thought. I would be very interested to hear what experience people attending have of using dispute boards. Feel free to mention it in the chat or to contact me after the event. But for now, moving on, I'd like to introduce Lewis Moore and Jeff Park, partners at international law firm Hill Dickinson. Lewis and Jeff are going to talk about how the English legal system is improving its processes with reference to delay claims. So, gentlemen, over to you.
Annyeonghaseyo. Ben, thank you very much for that kind introduction, and my thanks also to DIT for hosting this meeting today And my thanks also to the participants for joining us. If you just bear with me a moment, I'll just put some slides on the screen. Which have been helpfully translated for me by my colleague, Jeff Park. The problems with delay claims looked at from a lawyer's perception is that they are factually intense and they require a very careful analysis of the critical path of the workflow in relation to exceptionally complex engineering projects. The evidence that can be deployed in relation to delay claims falls into three categories. There is personal knowledge of the people who are involved in the project. There is the written record contained in documents and sometimes in computer programs. And there is the workflow itself, which may be contained in a detailed computer project scheduling platform, such as the Primavera. All of this has to be deployed and used should a matter become contentious. How can these issues be developed and improved in order to assist a yard deal with the delay claim? And I'm looking first at mediation and then secondly at arbitration, as most shipbuilding contracts do contain an arbitration provision. Mediation has proved a great success in assisting parties to resolve their disputes economically, quickly, and saving the relationship between parties as opposed to litigation. And we're now seeing a development with early intervention mediation, under which a skilled mediator is brought in at an early stage, speaking confidentially with the parties, somewhat similarly to the way in which a broker could do, as was discussed earlier, to enable them to try and reach a resolution to their dispute at an early stage before costs are incurred and positions become entrenched. There is another scheme which is now being developed called early neutral evaluation, and the LMAA recently announced its own early neutral evaluation scheme. Under this, an impartial and independent evaluator is appointed to provide the parties with a non-binding assessment of their dispute. This will give them a realistic indication of the merits of their respective claims and help them to inform their negotiations. And if appropriate, the evaluator can put forward figures for settlement or even ranges of figures for settlement purposes to assist the parties achieve a resolution. Again, a step before or can be carried out contemporaneously with arbitration proceedings. As Ben mentioned, the Arbitration Act has been a very important act in relation to London's position in international dispute resolution. And not only does it have a provision about resolving disputes without delay and without unnecessary expense, but it also contains an important principle in Section 1, which preserves party autonomy and says that the parties, the disputes are to be resolved as in the way in which the parties agree, subject only to public interest safeguards. The Arbitration Act is being considered now by the Law Commission, and there are some areas which they may well make some changes. Confidentiality is a complex issue. To what extent should parties be able to refer to a dispute that's been subject to arbitration, or to what extent should they be restrained from doing so? At the moment, this is dealt with under the English common law, but it may be that this will be a change that will be brought into a future statute. Also, dismissing unmeritorious claims and defences at an early stage is an issue that the Law Commission will review. Although in this respect, there is already some measure of power, because if the parties agree, preliminary issues can be dealt with, which can resolve the entire disputes if there is one key point that needs to be decided. And finally, appeals. There is a relatively limited power to appeal an arbitration award on a question of law. It works remarkably well, in my view. Very few arbitration awards actually get permission to appeal, and even fewer actually are reversed on appeal. we'd want to see as lawyers, and I'm sure as users, the continued development of English law. But at the same time, I do have sympathy that parties do not want to see English law developed at their expense. But there are other factors that can be deployed by parties at this stage without waiting for the changes for the Arbitration Act, which may come in the future. One possible way in which disputes can be short-circuited would be the adoption of a statement of agreed facts and issues, so that the parties from the earliest stage try and record what is in dispute and what is agreed in order to avoid time being spent on issues that are not relevant. Also, scheduling into an arbitration hearing breaks after the opening statements have been made by counsel, so that the arbitrators have an opportunity of reading the documents within the context of the way in which the parties are presenting their case. And I think that this would also enable proceedings to go forward more quickly, although I accept it does have a start and stop effect on hearings. Witness statements, and Mr. Michael Nolan QC will be, I think, talking about this later, have proved a particular problem. They should be what a witness knows from his own memory. They have become something totally different, overlong, over-argumentative, and unnecessarily expensive. The commercial court has turned its face against that behaviour, and there are penalties for those who try and use or abuse the system of witness statements. That is also a power that arbitrators are using more regularly in order to cut down on evidence which is either inadmissible or inappropriate. And finally, expert evidence in these sort of disputes is one of the most expensive areas. And that also can be addressed by limitations being placed on the length of expert reports, on the costs that will be recoverable for expert reports, should the party be successful. And also, I think that sequential exchange of expert reports can be adopted. That would then avoid both experts writing detailed reports on issues that may not be in dispute. And finally, the way in which experts give their evidence. We're also now seeing some hottubbing, an Australian development, coming into the process here, where the two experts give their evidence simultaneously. This does place something of an extra burden on the arbitrators, but as the experts are there to assist the arbitrators find the answer, then I think hottubbing in the appropriate case with the right experts is an excellent way of proceeding. And finally, if I may, I will mention a recent court decision of the Eternal Bliss. This was a demurrage claim where there was a ship was delayed in discharge because of charterer's instructions, and the dispute was about whether or not the owners who suffered a cargo claim because of the delay could claim those damages in addition to demurrage. And the Court of Appeal has held that where parties have agreed liquidated damages, such as demurrage, for delay, that is the extent of the remedy which is available. And given that shipbuilding contracts do contain liquidated damages clauses, this is obviously a very helpful decision for shipyards. So if I may, I will thank you all for your attention, and I will pass over to my colleague, Jeff Park, who is now going to talk about technology. And if I may, I will leave you in eternal bliss. Gamsa Habnada.
Just if I could butt in very quickly before Jeff takes over, we do have some slides which I think also accompanied Lewis's talk, which unfortunately didn't make it onto the screen, but those slides and these will be shared after the event in any case. So apologies for that, Lewis, and Jeff, over to you.
Okay, thank you, Lewis. Thank you, Ben. 안녕하세요. 저는 힐 디킨슨의 박정규입니다. 이번 코너에서 저는 한국에 계신 여러분들이 영국 중재재판을 화상으로 얼마나 효과적으로 진행할 수 있는지 살펴보겠습니다. 코로나가 시작된 2020년에는 영국 소송 방식에 큰 변화가 있었습니다. 평소 보수적인 법조계는 비대면 상황에서 온라인 기술을 적극적으로 받아들였습니다. 영국 법원과 중재재판소는 현재 종이 파일의 의존성을 낮추고 있으며 이는 다음과 같은 이점이 있습니다. 첫째, 종이 파일이 필요가 없어져서 비용과 에너지 절약의 효과가 있습니다. 둘째, 전자서류는 빠르고 쉽게 수정과 공유가 가능합니다. 셋째, 전자서류는 하이퍼링크를 작성해서 상호 참조를 쉽게 할 수 있습니다. 넷째, 이러한 장점은 면대면이 아닌 비디오 링크를 통한 화상 재판이나 화상 증인 신문에 적합합니다. 다섯째, 예를 들어 종이 서류를 바탕으로 한 증인 신문의 경우 수십 개의 종이 파일 중 하나를 골라 다시 그 두꺼운 파일에서 원하는 페이지, 원하는 문구를 찾아 증인에게 제시해야 하는 번거로움이 있습니다. 하지만 화상 신문의 경우 그 페이지를 바로 화면에 띄워 공유할 수 있기 때문에 매우 효율적입니다. 기술 발전에 따라 중재재판을 순전히 화상으로만 진행하는 화상재판과 변호사와 중재인들은 면대면으로 한 장소에서 모이지만 해외 증인신문만 화상으로 진행하는 하이브리드 재판을 가능하게 했습니다. 당사자들과 재판부가 재판을 순전히 화상으로 진행할지 아니면 하이브리드로 할지 결정하는 것에 달렸습니다. 면대면 중재재판도 여전히 그 역할이 있지만 당사자들이 동시에 같은 장소에 면대면으로 모이는 장점은 당사자들이 청문회에 참석하거나 증거를 제시하기 위해 해외로부터 먼 거리를 이동해야 하는 단점과 비교해서 결정해야 합니다. 100% 화상 재판에 비해 하이브리드 재판은 변호사들이 중재재판 과정에서 재판부로부터 면대면 피드백을 얻을 수 있기 때문에 유리합니다. 이를 통해 케이스를 더 강하게 압박해야 할 필요가 있는 포인트와 그럴 필요가 없거나 오히려 더 추진하지 말아야 하는 포인트를 알 수 있습니다. 화상 재판의 큰 장점 중 하나는 해외 증인을 신문하기 위해 재판 시간이 매우 신축적일 수 있습니다. 아시아에 있는 증인들에 대한 대질 신문을 위해 보통 런던 시간 8시 혹은 더 이른 시간에 재판을 시작합니다. 화상 재판은 이처럼 중재 당사자의 시간에 맞추어 시간과 장소의 제약이 적습니다. 따라서 면대면 재판 때 시차 적응이 안 된 해외 증인이 대질 신문을 받는 것보다 더 효과적이고 바람직합니다. 현재 런던 중재 재판을 위해 사용되는 가상 플랫폼은 모든 면에서 면대면 재판과 같이 효율적입니다. 당사자들은 재판 휴회 기간 동안 중재 재판룸에서 각자의 안전한 가상 미팅룸으로 원활하게 이동할 수 있습니다. 실제 면대면 중재 재판 과정에서 종종 발생하는 메모 전달 없이 화상 재판 중에 변호사와 고객이 서로 비밀리에 플랫폼을 통해 메시지를 주고받을 수 있습니다. 이를 반영하기 위해 최근 런던 해사중재협회, 즉 LMAA 2021년 개정법에는 포괄적이고 모범적인 화상재판 가이드라인이 기재되어 있습니다. 제가 지난 1월에 이 가이드라인에 따라 화상 중재재판을 진행했는데요. 매우 사용하기 쉽고 효과적입니다. 마지막으로 화상 조정, 즉 버추얼 미디에이션에 대해 잠깐 말씀드리자면요. 당사자들이 시간 내에 합의에 대한 압박을 느끼며 면대면으로 함께 만나는 것이 유리할 수 있습니다. 하지만 화상 조정을 통해 달성할 수 있는 조기 합의와 비용 절감의 가능성이 늘 열려 있기 때문에 화상 조정은 여전히 유효한 선택일 수 있습니다. 이상으로 비대면 업무 시스템과 온라인 기술 발달에 맞춰 런던 중재가 화상 재판을 통해 어떻게 시간과 비용을 줄일 수 있는지에 대해 살펴보았습니다. 이상으로 제 세미나를 마치겠습니다. 감사합니다. It's over to you, Ben. Thank you very much.
Thank you, gentlemen. Thanks, Lewis and Jeff. I'm sure it was a welcome relief for the audience to be able to follow part of today's presentation in Korean instead of English. So on behalf of everybody, thank you for that, Jeff. Our next speaker is Mr. Michael Nolan, QC of Quadrant Chambers in London, who is going to give us a barrister's perspective. Barristers are often appointed to represent parties in court or arbitration hearings, and Michael is going to highlight some developments in relation to evidence and hearings and suggestions for improving efficiency in litigation. So over to you, Michael. We are not seeing you yet, but I take it you're on your way.
Thank you, Ben. I hope you can see me now.
Yes, we can. Over to you. Thank you.
I apologize. I'm afraid I'm not going to be able to do this in Korean. But what I propose to do is to use the 10 minutes available to me to focus on 3 ways in which parties and tribunals can and do make the process of resolving delay claims more efficient. The first is by the use of preliminary issues. Many of the delay claims in which I've been involved have raised issues as to the construction of the contract and whether the type of delay claimed in fact entitles the builder to an extension of time to complete the building of the vessel. One I have in mind is a case where the buyers had cancelled a shipbuilding contract in a falling market pursuant to a provision in the contract which entitled them to do so in the event that the vessel wasn't completed within 225 days after the completion date specified in the contract. The yard alleged that the delay had been caused in part by the actions of the buyer's supervisors, and that delay didn't therefore count as non-permissible delay, and that therefore the cancellations were wrongful. The buyers denied that their supervisors had acted in any way improperly, and denied that their actions caused any delay, still less the delay alleged. If all the issues had been fought out in full, it would have been necessary to have evidence from the supervisors, from representatives of the yard, and from experts as to how much delay was in fact caused by the supervisors' actions. The buyers, however, had an argument that even if the supervisors didn't perform their functions properly, and even if they did cause delay in the building process, the builders couldn't rely on that delay, either because it wasn't permissible delay for the purposes of the contract, or because if it was, the builders were required to give prompt notice of it, and they hadn't done so. If they were right about that, they were indeed entitled to cancel the contract. The tribunal ordered the hearing of a preliminary issue, which in essence was, even if a delay of the length claimed was caused by the actions of the buyer's supervisors, did that count as non-permissible delay for the purposes of the contract? That issue was decided in the buyer's favour after a day of argument. The arbitration, which would otherwise have taken over a year to get ready for a hearing and would have involved about 2 weeks of evidence, was all over within 3 months. That arbitration took place after the contract had come to an end, but it's also possible, and it can be helpful, to have issues decided speedily while the contract is still being performed. In another case I was involved in, there was a substantial dispute between the parties as to the length of permissible delay allowed in the event of late delivery of design drawings. The builder said that the effect of the relevant clause was that if the drawings were 14 days late, it was entitled to 14 days permissible delay. The buyer said that the permissible delay was only that delay that was actually caused by the late delivery of the drawings. The issue was decided very promptly as a preliminary issue in the course of the project. That had the considerable advantage of letting each party know exactly where they stood, both as to the past and for the future, and put to rest a debate that had been causing a certain amount of friction between the parties. The second way in which arbitrations can be and are being made more efficient is by the greater use of virtual and hybrid hearings, which Jeff has just been talking about. There's been quite a long history of witnesses giving evidence from abroad by video link in arbitrations, but the events of the last 2 years have improved both the technology and parties' familiarity with it immensely, and have demonstrated that virtual hearings can work well, particularly in cases which involve just legal argument. When we first went into lockdown here in London in March 2020, both the commercial court and the arbitral community reacted with impressive speed to adapt their procedures to take account of the restrictions imposed by lockdown life. As Jeff has said, fairly early in the pandemic, the LMAA produced very useful guidelines for the conduct of hearings, and in particular for the creation of electronic bundles and for ways of ensuring, so far as possible, that witnesses giving oral evidence virtually do so without prompting or interference from people out of view of the camera. The advantages of virtual hearings in terms of cost and convenience are obvious. They also enable representatives of the parties who would not normally attend a hearing to do so remotely. The first one I did was for clients in Singapore and Malaysia who, even in normal times, wouldn't have come to London for a hearing, but were now able to watch proceedings remotely in their evening and to send me helpful messages by WhatsApp as the case progressed. There are, of course, disadvantages as well. One considerable benefit of parties attending arbitrations in person is that they're brought together at a time when minds are focused on the case and strengths and weaknesses are apparent in everyone's mind, and when those attending are away from the distractions of office and home and can focus on the case. Sometimes this can lead to settlement of even the most hard-fought cases and to a restoration of commercial relations between the parties. I remember one particularly contentious arbitration where both sides were accusing each other of fraud. Both the chief executives were smokers. At each break, both would rush out of the building to have a quick cigarette in the street. At first, they left the room separately and no doubt smoked separately. But by the end of the arbitration, they were leaving and returning together, chatting volubly and amicably as they did so. The dispute ultimately settled satisfactorily, and I have little doubt that that was in large part because the parties had been brought together by the arbitral process, and possibly also by the fact that both CEOs were smokers. Without a virtual hearing, however, there is no equivalent bringing together of the parties. Another disadvantage, from my perspective as an advocate, is that it is often harder to read a tribunal on screen, particularly if it's a tribunal of three, as is usually the case. When one is in the same room, it's much easier to tell if one of the tribunal is troubled by a point or hasn't found the right place in the bundle of documents. However, one of the many advantages of arbitration is its flexibility. As the world has started to open up again, we're seeing more hybrid hearings conducted in part in person and in part remotely. And I suspect these will become the norm, enabling the best bits of actual hearings and the best bits of virtual hearings to be combined. And now the third area where matters can and I think are being streamlined is in the area of the presentation of factual and expert evidence. To start with factual evidence, when I started in practice, the evidence of witnesses was given entirely orally. There was a process called examination in chief, by which an advocate would ask non-leading questions of the witness in order to adduce his or her evidence. That was time-consuming and inefficient, so the present practice developed of the evidence of witnesses of fact being given in witness statements drafted by their lawyers and exchanged before the hearing. A witness called to give evidence is normally now simply asked to confirm that his or her witness statement is correct, and is then immediately subjected to cross-examination by the advocate on the other side. Whilst this is efficient, it has, as Lewis Moore was saying, certain disadvantages. The first, and perhaps the main one, is that the practice developed of producing witness statements in which the witness gave a long account of everything that had happened in the case, referring to and quoting from many of the documents, regardless of whether or not they had written them. The result was that the statement of witnesses, whose involvement in the material events was relatively insignificant, became increasingly long and cumbersome. Another disadvantage was that very often witness statements contained argument, sometimes lengthy argument, as to the merits of the case, which again made them longer than they needed to be. A third was that sometimes the statement, both in terms of terminology and emphasis, was more the statement of the lawyer drafting it than it was of the witness himself. The Commercial Court has recently sought to clamp down on all of these practices. A practice direction now provides that witness statements should only contain matters that are within the knowledge of the witness giving them, should not contain argument, and should not set out the contents of documents, or indeed refer to documents at all, save where necessary. It should be based on notes taken at an interview at which the witness is asked non-leading questions so as to adduce their evidence. And the direction provides that if these guidelines aren't followed, then evidence may be excluded or there may be cost consequences. I would expect in the future, to the extent that it's not already being done at the present, the same practice will be expected in arbitration, with witness statements becoming much shorter and with a consequent saving both in time and in cost. And finally, in some cases, as Lewis has said, expert evidence can be given more efficiently by hot tubbing. At present, in most cases, once there's been an exchange of expert evidence, the experts meet to discuss their reports and to compile a list of matters they agree on, matters they disagree on, and the reasons for the disagreement. If the experts are equally good and are left to carry out this process without interference, as they should be, this can be very efficient. It focuses the area of the debate and it shortens the hearing. Hot tubbing takes that process one step further, so that at the hearing the experts give their evidence concurrently rather than one after the other. Each area of disagreement is dealt with sequentially, with both the tribunal and the advocates questioning both experts, and the experts asking questions of each other before moving on to the next topic. My own experience of it has been mixed. There's a danger, if it's not tightly controlled, that the discussion becomes a free-for-all, but there are cases in which it can be very effective. Like the other matters I've discussed, the question whether or not hot tubbing is desirable in any particular case will depend on all the circumstances. Different cases will demand different procedures, but one of the great advantages of arbitration is that it allows a great deal of flexibility to the tribunal and to the parties as to how most efficiently to deal with the particular challenges of any particular dispute. Thank you for listening, and I will now hand over to David Steward to give you the arbitrator's perspective.
Thank you very much for that, Michael. Just before I hand over to David, just to thank you. I think you've highlighted some topical recent developments, and I certainly agree that virtual hearings have served to greatly increase flexibility when it comes to timetabling and provide scope for significant time and cost savings. And you also highlighted the use of preliminary issues, which is interesting. I think perhaps something that we can come back to at the question and answer session at the end. On that note, please feel free to submit any questions using the chat function on your screen. We have a few lined up already, but very happy to hear from the audience and address any questions in the Q&A. Before though, our last speaker is a fellow arbitrator and president of the London Maritime Arbitrators Association, LMAA, Mr. David Steward. David will share some thoughts from an arbitrator's perspective. So over to you, David.
Thank you very much, Ben. A very good afternoon to you all. I'm sorry that I can't be with you there in person. It's far too long since I was last in Seoul, Ulsan or Koji Island, but I'm very happy to be taking part in this webinar today. Now, from the perspective of an arbitrator, I would like to suggest 3 ways to help to reduce the cost of resolving delay claims. 1, choose your arbitrator. 2, control the timing and extent of delay analysis. And 3, choose your method of analysis. So first of all, choosing your arbitrator. In my experience, it is best to have arbitrators who understand the various possible approaches to delay analysis, at least in general terms. There should be no learning curve. Otherwise, you may spend a lot of time in written submissions and at the end of during the hearing, educating your arbitrators. I suggest preferably someone who has handled delay cases as a party representative or as an arbitrator before. If you use people who don't have relevant experience of delay analysis, this can lead to wasted time and cost. Now you have the choice. Subject to conflict of interest and bias, there are no restrictions on who you can appoint in LMAA arbitration unless your arbitration clause says so. They don't even need to be members of the LMAA, but we do have arbitrators with experience of delay disputes. Now, you have no control over your opponent's choice of arbitrator, but you can always discuss this with them at the beginning of the arbitration. You might consider, for example, suggesting that you agree to have a scheduling expert with arbitration experience on the tribunal. At least if you yourselves appoint someone with relevant experience, they will contribute to the decision, and it's less likely that they will agree to an unsuitable third arbitrator. Secondly, timing and extent of evidence. Please don't leave it too late to bring in your expert. You don't want your expert to prepare evidence in a hurry at a late stage of the arbitration. I had a case recently where the parties waited until the hearing date was fixed before instructing scheduling experts. Neither expert was able to carry out a sufficient analysis in the time available. And also, by the time they reported, substantial costs had already been incurred on other aspects of the case. I think it's best for the parties to see where they stand as soon as possible in the arbitration, because this has an impact on the preparation of the case as a whole. For example, when you know the position on delay, other parts of the dispute may become irrelevant. In my experience, it's best to get a preliminary view from an expert rather than try to start by investigating every possible fact at the outset. You can never do a perfect job, and arbitrators don't expect you to do so. We have to decide the case on a balance of probabilities. When I was in private practice as a lawyer representing shipyards, I always got an expert to go into the yard as soon as I knew about the dispute. That expert spent a few days to take an initial high-level view on the causes of critical delay. And they did this before the lawyers started any preparation of witness evidence and documents. It helps you to see where you should focus your work and to avoid unnecessary cost. As an arbitrator, I like to see scheduling evidence at the stage of initial submissions in arbitration. This should certainly include any project schedule, a level 3 schedule, and if possible, as-built documentation. As-built data includes site records, photographs, and so on, and they're very important because they show the facts. As arbitrators, we need to know what happened, when it happened, and why it happened. And the as-built data will help the experts to try to agree these facts. If, as Lewis suggested, there can be agreement on the facts, at least to some extent, then the delay analysis will be easier. So the sooner the parties share their evidence, the sooner they can prepare their cases. Also, help the arbitrators to give directions for the procedure in relation to the delay claim. They might, for example, require the scheduling experts to have discussions at an early stage and report back to the arbitrators. Please keep control of your experts and control the time they use. I had a very useful tip from some experts once. They said, first of all, identify parameters at the beginning of the work. Tell the experts how long they have and how much cost to budget for. Then the experts do the work to the level of detail that is possible within those parameters. Now, thirdly, choose your type of analysis. The choice of the type of analysis will depend on the circumstances of the individual case. For example, how good the records are from the project and what kind of schedules have been used during the project. But there is one key point that applies in all cases. As an arbitrator, I want to see an analysis which shows what happened as far as possible. I don't find it helpful to have something artificial or theoretical. Please focus on the facts. There's a useful quote in the textbook Keating on Offshore Construction and Marine Engineering Contracts, which says, "The correct analysis of causation of delay will differ widely on different facts and on different contractual regimes. It is submitted that the cases demonstrate that the focus will always be on identifying the events which, as a matter of practical reality on the project, were causing delay to the progress of the works overall." A few years ago, I handled a case involving the topsides for an FPSO. One expert produced a clever conceptual analysis of delay using a very sophisticated computer program. The problem was that it was too theoretical. It didn't show what actually happened during the project. It's interesting also to read the judgment of Mr. Justice Hamblin in the Adyard case. That's an example of a case where a party argued for an unrealistic conceptual approach to causation, and the judge rejected it. We don't want to see hypothetical answers about potential delay. We want to know the actual effect of causes of delay. So you might, for example, use a Windows method. That's only one possibility, and I recognize that it has limitations, but please bear in mind that nothing is perfect. There's always a balance between, on the one hand, the thoroughness of the analysis, and on the other hand, the cost and time. But the Windows method can be useful because you look at the delay in periods which correspond to the progress reports during the project, for example, monthly reports. You look to see what happened in each window and what was affecting the critical path. If you get more information later, you can go back and adjust the analysis in a window. Brief word on techniques to help in resolving disputes. You might consider having a dispute board on your project, and Ben has described how this works. When a dispute first arises, you might want to consider mediation, early neutral evaluation, or ENE, as described by Lewis. And you may find it helpful to know that the LMAA publishes on our website lists of members who are willing to accept appointments for DRBs or as mediators or evaluators. And as Jeff explained, we are frequently using virtual and hybrid hearings to reduce the cost of arbitration. Thank you very much for your kind attention.
Thank you, David. Certainly some very valid points to highlight. Just picking up on your point about party autonomy and picking the right arbitrator, I mean, that's clearly very important. There was an interesting study done a few years back by the Queen Mary University in London, highlighting the benefits of an arbitration tribunal having a sort of diverse range of backgrounds rather than 2 or 3 arbitrators all with similar backgrounds, legal backgrounds, for example. So cognitive diversity, they referred to it as, and quite an interesting study. I think it was some years ago now, possibly around 2018, but delves a bit deeper into that whole issue. So that concludes the presentation stage of today's session. Thanks very much to all of the speakers. I hope the audience has found them useful. Many topics have been touched on, all of which help to speed up resolution of disputes or to avoid them altogether. We've talked about better use of the broker in the first place before the dispute escalates fully into a full-blown legal dispute. We've introduced the idea of dispute boards, which generally are not really utilised in shipping in any context yet, but they're certainly another form of dispute avoidance and resolution that is gaining traction in other industries and could be well suited to certain shipbuilding contracts. Jeff and Lewis have talked about technology and the use of early neutral evaluation, mediation, and various other things. And we've touched on different aspects of the actual litigation process that have been developed to speed up the process. I think through a current sort of common theme through all of these things does also bring back to the concept of party autonomy and the fact that the parties actually under English law and under the Arbitration Act have a lot of control over how their dispute is resolved. And that is certainly a feature of arbitration versus litigation through the courts. And perhaps to kick off the Q&A session, I'll throw it out to the panel, and maybe we should all put our cameras on here so the panel is all on screen. How is the concept of party autonomy actually being used to its full extent, and can parties do more to control it themselves? Is it such that there is one way of running an arbitration, and parties are not pushing the agenda enough in terms of preliminary issues or declaratory awards? So let me throw that one over to the panel and see who would like to pick that up first. Any volunteers? David's got his hand up, so please go ahead, David.
Yes, thank you, Ben. I'd like to pick up on a very important point that Michael made about preliminary issues, and which you just mentioned also. And I do encourage parties to think about asserting the importance of preliminary issues. I've just completed an award on a shipbuilding case very recently, where we were heading towards the delivery date. There were issues over permissible delay, and it was unclear how the final instalment payment would be calculated, how the contract price would be adjusted for the purpose of delivery. And one party said that it would be convenient to decide this as a preliminary issue. The other party resisted, but we, the tribunal, decided that it was very important to make a decision on this. And so we ordered that we would decide the interpretation of the relevant clause as a preliminary issue. And from the time of our appointment to the time of our award was about 7 or 8 weeks. And we were able to give the parties a clear decision on how to operate the relevant clause of the contract to calculate the final instalment payment and to leave the permissible delay claims to be resolved at a later stage. So that's a very good example of exactly what Michael was talking about in terms of the parties coming forward and asserting that there's a useful preliminary issue to be determined.
Yeah, thanks, David. I mean, I've had a similar example, or a different example, I guess, that I can give, but in a chartering context, where where the parties wanted to establish basically at the outset of the arbitration whether the owners were entitled to discharge the cargo at a different port. So, interpretation of a charter party clause. And obviously that would determine everything subsequent in the arbitration. So certainly that is being used, but I do agree. Preliminary issues and declaratory awards are something that can that should be used and can certainly speed up resolution of disputes once they've got as far as arbitration. Another question we have in is regarding the review of the Arbitration Act. What do the panel think is likely to be included in that review? So anyone like to tackle that one? Lewis or Michael, perhaps?
Let me start. I know that fairly early on in the life of the Arbitration Act, there was a lot of discussion about whether or not there should be some method of enforcing consolidation of disputes, because it can be quite unsatisfactory to find that there is a third party who really should be involved in the dispute, but because then they've got a different arbitration agreement, a different panel is deciding the issues between in relation to one dispute that actually involves three different parties. And in an absolutely ideal world, a method would be found to ensure this, but it is very, very difficult. The attempts that were made to do so, to make alterations in the past, stalled really because the underlying philosophy of the Arbitration Act is party autonomy and the agreement of the parties. And it is one thing to say that if parties agree to have their disputes resolved by a particular body, and if they agree to the rules of that body which allow for consolidation to apply, that they should then be bound by those rules. But to force a party who has simply agreed to arbitrate its disputes without referring to any particular set of rules, thereafter to become involved in an arbitration to which it hasn't agreed to join is a different matter altogether. And I don't know whether the present review of the Arbitration Act is looking at this again. I hope it does, but I'm at the moment not entirely sanguine that there's going to be a very satisfactory solution to it, apart from parties who want to be able to have their disputes consolidated with other disputes signing up to a set of rules which allows that. But of course, that's only going to be effective if the third party also sets up those set of rules. So it's an intractable problem, but one that it would be nice for a solution to be found to. At the moment, arbitrations in front of the LMAA very often end up, if not consolidated, at least being heard concurrently. And that does get around some of the problems that can arise from there being more than two parties involved. And I found that LMAA arbitrators are very amenable to the idea that the third arbitrator appointed in any two arbitrations will be an arbitrator from the related arbitration, so that one ends up with the same panel deciding concurrent arbitrations, even though the two arbitrations are, strictly speaking, separate ones.
Yeah, thanks, Michael. Anyone else want to chip in on the subject of the Arbitration Act and the ongoing review? No, I think Jeff, go ahead.
Yeah, obviously, when Arbitration Act 1996 was enacted, there was no technology like now in terms of virtual paperless technology. So I think the Law Commission should consider how the LMAA terms 2021 adapted the technology in terms of the virtual and hybrid arbitration hearing. So, David, you may advise the Law Committee about how the Arbitration Act can adapt the new technology by virtual hearings.
Thank you, Jeff. That's a really important point. People may be aware that our guidelines on virtual and hybrid hearings now form the 6th schedule to the latest version of the LMAA terms. And my personal view is that they are very practical and they give very clear guidance. I guess you could say it may not be necessary for that to be incorporated into a statute for all arbitrations, because each institution and organization will probably have its own practices and its own guidelines. But yes, I think the Law Commission will have to consider whether there are any changes that need to be made to reflect the change in technology. It's an interesting point, Jeff. Thank you.
Lewis, did you want to chip in? Oh, you're on mute, Lewis.
There always has to be one, doesn't there? In addition to the points I mentioned, I think also that the Law Commission is going to look at the powers that the court has to help arbitrators in circumstances where the arbitrated panel is not able to give relief and urgent relief is required. I think there's been a recent case concerning the LCIA, where because the LCIA has power to appoint emergency arbitrators, the court couldn't step in and give other relief. Now, I'm not so sure that this is something that well, maybe shipyards feel they do need urgent relief every time a delay claim comes up, but I'm not sure that's a process that's necessarily going to be of assistance, but it is part of the wider ambit. And I think also the procedure for appointing arbitrators where there is a default is something that could be speeded up. The way it's done at the moment, requiring a notice and then a further notice, and a court application if it's a sole arbitrator, is, to my view, it's unnecessarily protracted, and the LMAA again, I think, should be congratulated in their latest terms, because they've very much streamlined the process of appointing arbitrators where there is a default. And again, that is something that speeds things up, getting the arbitration moving quickly without having to recourse to court applications to appoint arbitrators or serve several notices. I think that's been a great improvement as well, but it's something that the Act could also address.
Yeah, interesting. Thank you. Moving on to something else, Lewis, in your presentation talked about statements of agreed facts, statements of agreed issues, which in an arbitration context often come closer to a hearing, which is towards the back end of the arbitration, as opposed to at the front end of the arbitration. So I think it would be interesting to get some views in terms of preparation for an arbitration and collecting documentation, and maybe this is something that Thomas has a comment on from a more commercial broker perspective. Are shipyards, generally speaking, is there sufficient evidence, factual evidence, documentation to sort of to evidence the dispute available and exchanged early enough in proceedings to help define the issues and achieve that? Because it's a valid point that's worth re-emphasizing, that if facts and evidence or facts and issues are agreed early on, then that serves the purpose of defining better the dispute for the rest of the arbitration. So Thomas, I don't know, from a commercial, do you want to kick that off in terms of documentation? In your experience, how much is that aspect written into the shipbuilding contract, and how clear is it? What paper trail is being generated at the outset of these projects?
It's an interesting. I'm not really sure I know how to answer. I mean, there is a very clearly defined specification, and therefore one should be able to, certainly from a technical, if the delay is caused purely by a technical issue, one should be able to come to a fairly quick conclusion as to whether that there should be enough documentary evidence to decide on the at least the parameters of the discussion. But I'm not sure I have necessarily a very strong. I think it very much comes down to the dispute in question, and whether there is. The reality is there are so many motivations behind a dispute, and I mean, as Michael raised with one of the disputes he discussed. I mean, there's often there's often a desire by the ship owner in many cases to encourage the delay and to encourage the default, and to through arguing against delays being permissible, and it's, I think it's sometimes quite complex to provide documentary proof really one way or the other to set out the claim at the outset, because it's almost a moving target depending on the motivation of the two parties. If they're there to really agree to a solution, then it's straightforward. But actually, when one party perhaps doesn't really want to agree, then it becomes much more challenging. And the reality is that is often the case. I'm not sure I can add anything more than that.
Yeah, no, I think that's fair. Thank you. Anyone else want to comment further on the time of agreeing statements of facts and issues? David, you raised your hand. Thank you.
Yes, thank you, Ben. I think from an arbitrator's perspective, this comes back to the point I was making about getting the experts involved and talking to each other at the earliest possible stage in the arbitration, certainly in relation to delay claims. The LMAA terms require that when parties put in submissions, they should accompany those with supporting documents. But what often happens in practice in complex cases is that there are only a small number of documents disclosed at the beginning, and then you have a large disclosure process at a later stage in relation to the whole of the case. And I think it's really important for arbitrators to find ways to short circuit that. So where there's a major delay and disruption dispute, and we need to focus on identifying the critical path and finding out what the cause of delay is, then my preference would be to get the experts talking to each other early on, to get each of them to come up with a list of the documents that they would like to see, the as-built material that they would like to see to help them form a view, and for the tribunal to require the experts to report back to them frequently on progress in their discussions with a view to agreed statements and narrowing the issues. So I think there's a role to be played by both the party representatives and the arbitrators in ensuring that that happens efficiently.
Yeah, thank you, David. Lewis, I think you had your hand up.
Yeah, just to follow on from that point that David's making, what happens often with arbitrations is that the experts serve reports and exchange reports. They then have a meeting, and then they will prepare on the basis of that meeting points of agreement and points of dispute, and possibly serve further reply reports dealing with the issues that have come out in points of dispute. Now, that comes a long way down the track in terms of an arbitration. It's post the disclosure stage, it's post the witness statements, all the pleadings are closed. Parties have engaged in a very big spend at that process. And I think what we should be doing, and I think David's point is absolutely spot on, that we should be getting to the point of knowing what the experts' cases are, what they can agree and what they can't agree at the earliest stage in the proceedings, and that's going to enable the parties either to resolve their dispute or short circuit it.
Yeah, I can't agree more. I think that well, we're actually running fairly quickly, running short on time here. That is the end of the questions that I fielded here. So unless anybody on the panel wishes to make any final closing remarks, then I think we'll draw proceedings to a close. Any takers? Going, gone. No. So that is all we have time for. Sincere thank you to all of the panelists for providing some excellent insights and perspectives, which I'm sure has provided all of us with plenty of food for thought. I hope that it has. Thanks also again to Maritime London and to the Department of International Trade for hosting this event, and indeed for their commitment to supporting business between UK firms and Korean shipbuilders more generally. Thanks in particular to Ambassador Crooks for his welcoming remarks. Finally, thank you to the audience for attending. We hope you found it useful. Please feel free to follow up with any of today's speakers. Contact details have been provided and can be provided again, and we're more than happy to address further questions or general follow-up from today's discussion. So please feel free. So goodbye for now, and kamsahamnida.
Thank you all. Goodbye.